episode 5 of For the Good of the Game, a podcast where we examine the issue of public interest litigation through the lens of one case, the challenge to stop the 1985 All Blacks tour of South Africa. Where we last left off, the plaintiffs and the rugby union were anxiously waiting the decision of Justice Casey in the High Court as to whether he would grant an interim injunction preventing the All Blacks from leaving New Zealand before the conclusion of a full hearing. The plaintiffs and their lawyers had applied for an interim injunction because they were worried that otherwise, by the time the case had finished, the tour would have begun and the case effectively would have been lost. The rugby union had argued that if the interim injunction were granted, the tour would not just be delayed, but it would have to be cancelled. The interim injunction had been argued on a Thursday and a Friday, and the judge announced he would reconvene the court on the following day to deliver his decision. On the morning of Saturday the 13th of July, the High Court in Wellington was packed. Journalists, pro- and anti-tour activists, lawyers, and representatives of the rugby union crowded the courtroom, while an even larger crowd waited outside. The room fell silent when Justice Casey entered and began reading his decision. Ted Thomas remembers the day.
There wasn't a seat to spare in the public area, so the courtroom was full, and then out on the road, people heard that, the decision was going to be given, and they filled up the roadway. It must be, I wouldn't like to estimate the number because they're good at that, but there would be any number. But sitting alongside John Marshall, I said from time to time, we've lost. And then he'd say something, we'd think we had a chance again. And then I'd think, we've lost. And it went like that, up and down.
It's important to be really clear about what this judgment was actually about. The court wasn't deciding the broad moral issue about whether it was right or wrong to maintain sporting contacts with South Africa. It was much narrower than that. What the court was being asked to decide was whether an interim injunction should be made preventing the All Blacks from travelling to South Africa until all of the plaintiffs' case had been heard. If, at a later trial, the plaintiffs could persuade the court that the rugby union's decision was outside its own rules, then the court might make a permanent order cancelling the tour. But for now, the effect of any order would only be temporary, and would preserve the position until the full matter could be resolved. Of course, as we heard before, the rugby union didn't see it that way. They had presented evidence from the All Blacks coach and the New Zealand police, saying that if the interim injunction were granted, the tour would have to be cancelled, regardless of what a court might say later at a full trial. The established precedent in these types of cases, known as interim injunctions, set out a 3-stage test. The first part of the test is to decide whether the plaintiffs have raised a prima facie case. In other words, whether the plaintiffs have been able to show that it was least arguable that the rugby union's decision was unlawful. Justice Casey found that there was a strong case to say that the tour of South Africa would not be good for rugby in New Zealand, and accordingly contrary to the rugby union's constitution. I'll read from the judgment in Justice Casey's own words. He said, "The 1981 Springbok tour of this country was a disaster, both for rugby football and the community, which was widely and sometimes violently split over the question of that sporting contact with South Africa. The courts encountered numerous cases of otherwise perfectly respectable people at odds with the law for the first time. The inescapable fact is that a very substantial number, perhaps even approaching half of all New Zealanders, are opposed or upset about this tour on grounds which appear to include the good of rugby, New Zealand's international standing or trade, the interests of other sports likely to be affected, or moral reasons connected with hatred of apartheid. The plaintiffs are on strong ground when they say that such an attitude, spread so widely among all sections of the community, must inevitably tarnish the image of the game and lead to a drop in support and interest and a reduction in potential players." Justice Casey then set out 2 possible standards which could be used to decide whether the rugby union had acted unlawfully. The first was the standard usually applied to companies and incorporated societies such as the rugby union, which is to decide whether they had acted honestly and in good faith. Justice Casey found that there was a strong case that the rugby union had breached this duty by becoming sidetracked into a battle with the Prime Minister. You might remember the meeting between the union and the Prime Minister, which we covered in the first episode. The judge commented that the evidence, such as minutes of the rugby union's meetings, seemed to show a determination not to play into the Prime Minister's hands, rather than any genuine desire to listen to what he had to say. It's important to note at this stage that Justice Casey wasn't coming to any final decision. His job at this stage was just to decide whether there was a prima facie case. That part of the test had now been met. Justice Casey also suggested that there was a second, more stringent standard that the rugby union might also have to meet. You might remember that in its list of 8 reasons that the Court of Appeal gave for allowing standing, the court said that in some ways, because the decision was of such major national importance, the rugby union needed to be treated as if it was a government body. Justice Casey picked up on this suggestion and applied it to the test for an interim injunction. Under this approach, the rugby union would have to do more than simply act honestly and in good faith. Because of the rugby union's importance in New Zealand society, it should be held to a higher standard than other private organisations. The judge then came to the next part of the test for an interim injunction. He considered the consequences the injunction would have on the rugby union. Justice Casey acknowledged that the rugby union had a lot to lose from the decision. Part of that was financial. All the money it had spent getting ready for the tour would be wasted, especially if the interim injunction resulted in the tour being cancelled. He also noted that many people had booked flights and travel packages to watch the All Blacks play in South Africa. They would lose their money and be inconvenienced. However, Justice Casey was not convinced that the interim injunction would necessarily mean that the tour would have to be cancelled. Rather, if the rugby union eventually won the case, the tour could go ahead at a later date. In other words, Justice Casey did not accept the evidence from the All Black management and police that the result of the interim injunction would be to cancel the whole tour. Justice Casey had now gone through the first 2 steps of the legal test for an interim injunction. He had accepted that the plaintiffs had a strong case. But against this, he had also acknowledged that the interim injunction would cause considerable loss to the rugby union and others. He then proceeded to the 3rd stage of the test. This is where the judge, in all the circumstances of the case, exercises his or her discretion to decide whether an interim injunction is appropriate. At this stage of the judgment, Ted Thomas and the other lawyers still weren't sure whether they had won. Justice Casey could have decided that there was no reason to interfere with the rugby union's own private decision. But instead, he decided that the tour of South Africa needed to be seen in a wider context, and it was contrary to what he described as the interests of the public and of the nation. It was contrary to the government's direction, the unanimous resolution of Parliament, and could damage New Zealand's international relations. Justice Casey also acknowledged Arnold Stofile's evidence about the possible violence it could cause in South Africa. Taken together with the strength of the plaintiff's case, the interim injunction was granted.
We all stood and he left the courtroom, and then within a few seconds there was this mighty roar from outside. Mighty roar! It's loud as hell. However many hundred were there, everyone roared. And I told the troops, I don't know what I had to do, but I told the troops to go out and stand on the court steps. We got a massive reception.
Although some people may have been celebrating at the court, the reaction was different elsewhere. The journalist Phil Gifford was at Eden Park, where a round of club rugby was being played.
In those days, no mobile phones, but people had transistors to listen to commentaries and stuff. Somebody came up to me, and I can't remember who it was now, and went, "The tour's off, the All Black tour's off." Oh, why? And then they said, that bloody court case. So, it's been announced that the lawyers, which is how Rocky and Paddy Filling were always described. Yeah, that's somebody said it's off. And it was like, you could almost see people around Eden Park. Because in those days, club rugby got a lot of people going to it. You know, yeah, it was a hell of a shock to me, and I was backing them. So what sort of shock it was to people that never dreamed that these pricks could actually stop a tour, I've got no idea. It must have been extraordinary, I think. You know.
This wasn't the end of the road for the plaintiffs. The rugby union still had options. Although the team could not leave for South Africa, they could appeal the interim injunction to the Court of Appeal. In fact, the Court of Appeal indicated it was ready to hear the case the following week. However, throughout the court hearing, the rugby union had indicated that if the tour was delayed, it would probably have to be cancelled. On the Monday following the High Court's decision, the New Zealand Rugby Union chairman, Cess Blasey, confirmed that the proposed tour would not go ahead.
The tour, which was scheduled to have the first match played on the 24th of July, and for which the players were to have departed this week, that's been cancelled for practical reasons.
New Zealand Rugby Union Chairman Cess Blasey speaking in Wellington today as the latest round of the South African tour controversy unfolded. Insight 85 this week looks at the developments.
The practical reasons that Cess Blasey referred to were factors such as the logistics of reorganising transport and security, the mental state of the players, and the climate conditions in South Africa later in the year. The All Black coach, Brian Lahore, had made these points in his evidence in court, and they were further explained by the rugby writer Alex Vasey in an interview soon after the trial.
The players would have been so flattened mentally by this decision when they were at a high state of psychological and physical readiness for a very difficult tour that it would be impossible to bring them back to that state for a South African tour.
The other thing that's been suggested is that, in fact, if the tour was delayed, the grounds in South Africa would be too hard to play on.
Well, if the tour were delayed to the extent that it stretched out into October, then it would be nigh on impossible to play a game of rugby, for instance, in Durban, where humidity would be about 100%, I would think, and where the ground would be like rock.
Later that year, the rugby union would unsuccessfully bring an appeal against the Court of Appeal's standing decision, which we looked at in episode 3. In particular, the rugby union was concerned that the standing decision set a precedent allowing individual members to challenge its decisions, and it was particularly concerned that courts might develop the more stringent test of treating the rugby union, despite being an amateur organisation, as if it were a governmental body. However, neither the Court of Appeal in New Zealand nor the Privy Council in London, which at the time was New Zealand's highest court, were willing to hear the case. That appeal would have no bearing on the 1985 tour. It was definitively cancelled. The reactions in New Zealand were, unsurprisingly, mixed. Those who were against the tour were delighted. The Prime Minister declared that he was proud to be a lawyer. Kevin Haig, one of the leaders of the anti-tour organisation HEART, was also delighted.
Well, I mean, obviously we were hugely thrilled. I mean, in the same way that after we'd succeeded in cancelling the Hamilton game in '81, we thought, this is it, they can't possibly continue with the tour. And so the celebration was amazing. Same thing after the court judgment.
Those who were pro-tour, however, were very disappointed. Cess Blasey tried to remain calm, but recognised that many others were furious.
Well, judging by some of the reactions I've had, there are a lot of people who are very, very, very disturbed about the whole thing. Probably we need to think about it a little longer. The only thing we can be certain about, of course, is that, as I have said on many other occasions, in a variety of circumstances, that I haven't got any doubts at all that New Zealand rugby will survive and will remain strong.
Meanwhile, in South Africa, Danny Craven, the head of the South African Rugby Board, refused to answer any questions.
Mr. Craven, the rugby union here in New Zealand has announced that the scheduled tour to South Africa has been cancelled.
I know all about it.
Can you give us any comment?
No.
Can you give us any reaction, a personal reaction to that decision? Can you
comment.
Can you give us any idea if there's a possibility that the All Blacks may never go to South Africa?
No comment.
Part of the reason for these negative reactions was that many people wanted to watch the All Blacks play their greatest sporting rivals. But there was a deeper reason that so many people were uncomfortable with the court's decision. They felt that it was inappropriate for a court, made up of unelected judges, to tell a private organisation such as the rugby union what it could and couldn't do. This was reflected in the reaction of Murray Mexted, one of the players who had been selected to go on the tour.
I guess I'm a puppet in the game, you know. I'm no longer an individual. I have to sit by and see what the powers to be will do. I think I'll probably grab my surfboard and go surfing, but perhaps I should check with the courts and Mr. Longy to make sure it's legal to do that these days.
This comment relates to an issue that we've been looking at throughout this podcast: the role that the courts play in making decisions of national importance. Many people felt that the Rugby Union Council was entitled to make whatever decision it thought was best. If the decision was really one that was important to all New Zealanders, then perhaps it could have been made by the government, but not by a judge. Judges are not elected, and they do not have all the information that a government department or politician might have. Partly because of this, many people believe that it is not the role of a judge to consider moral or political issues. Yet as we have seen, that is exactly what Justice Casey did. He looked beyond the rugby union's own rules and examined the effect that the decision would have on New Zealand as a whole. Justice Cook had done the same thing in the Court of Appeal. Accordingly, many people felt that the courts had overstepped their role. This is a concern that should be taken seriously. It is clear that not every issue should be decided by a court. I asked some of the participants whether they thought that this particular issue was one that the court should have determined. All of them recognised that this was a complex question. Here's Paddy Finnegan's response.
The answer to that is yes and no. It would have been better if the rugby union could have determined it itself, but it couldn't. And it seems to me that the last resort of the courts, and people will respect the courts, particularly if it's a reasoned decision. And Casey's was a reasoned decision. He backed it up with saying, well, we've got a strong case suggesting lack of good faith. And I mean, look at, for example, Brexit. The House of Lords has probably done a heck of a lot to calm that down and put it back on the correct political path. Whereas if there hadn't been a court challenge, you could imagine that these sort of things could tend to get really out of control when they say, well, look, or you just went ahead and did it as an executive act. But there are times when the court does get involved in controversial issues.
Chris Laidlaw, the former All Black who worked as the Prime Minister's foreign policy advisor, gave me a similar response. He was surprised the court had intervened, but felt it was the only decision available.
Well, if that's the only way to get a result, then okay. I mean, there's nothing particularly healthy about any court decision, I don't think. Anything has to go through a court to be resolved. And this was a very unusual hearing and a very unexpected result. I didn't for a moment think that Justice Casey would have the breadth of vision should be able to stop it on the grounds that this was not good for New Zealand rugby, not in its own interests. And we were astounded to learn that had happened.
What Chris Laidlaw is saying is that the court process was not perfect. But in the context of the 1985 All Blacks tour, where the government was not in a position to make the final decision, the court process was the best possible way to do it. At the end of the day, there is no absolute right or wrong answer as to what decisions should be made by individuals, what decisions should be made by Parliament or the executive government, and what decisions should be left to courts. Courts have developed their own legal principles, such as standing, to help them determine which cases are appropriate to decide. But there are also other, non-legal factors we should consider. We will never know exactly how Justice Casey's mind worked in deciding to grant the interim injunction. but it seems very likely, on the basis of his judgment, that he was influenced by the political and social context of his time. The idea that a judge might be influenced by non-legal factors, such as these, is known as legal realism. I asked Rodney Hanson, one of the lawyers in this case and later a High Court judge, what he thought of this idea.
Because I know, having since been a judge, that you can talk what you like about legal realism and various theories of law, but the reality is that judges strive to do justice as they see it. And in one sense, the law becomes a means to achieve that. And I, for myself, see that in one sense, the law becomes the servant. I always took the view as a judge that if the law required me to reach an unjust result, then I hadn't got the law right. So I do think that social conditions, attitudes, and and just simply the way that you can kind of mould and shape a case do influence what is happening. That's how the law changes and evolves and progresses and reflects what is going on in society.
Although we will never know, it is possible that Justice Casey made his decision considering the legal principles and social context, but ultimately based on what he thought was most just in the circumstances. Justice is an elusive concept. It might relate to ideas beyond what is written in the statute book or set down in legal precedent. The challenge for judges is to apply statutes and precedents in a way that does justice in a particular decision. As a Court of Appeal said, the best way to do this will depend on each individual case. In some cases, such as Finnegan, a judge may need to consider factors and outcomes that touch on political or moral subjects. That is where the line between law and politics becomes very blurry. Hopefully, throughout this podcast series, you will have had a chance to think about this issue and will have developed an understanding of the role that courts play in our system of government. Before we end, it's worth asking whether the proceedings in Finnegan really had any long-lasting impact. In making this assessment, it should be noted that the decision did not stop many of the All Black players from touring South Africa. In the following year, 1986, most of the All Black team travelled to South Africa under a different name, the Cavaliers. But the team went without the official endorsement of the New Zealand Rugby Union, and many of the players were banned and dropped from selection on their return. No official New Zealand team played South Africa again until the end of apartheid. But it's hard to say whether the tour had any effect in ending the apartheid system. Many historians agree that boycotts and sanctions had some effect in bringing down apartheid, but that economic, rather than cultural sanctions, were most effective. Rodney Hanson was modest when I asked him about the impact of the case.
I don't know how you can say what the cause and effect was, and I wouldn't presume. I honestly wouldn't be able to express a view on that, because I think that was a cumulative kind of thing. It's a drip, isn't it? It's a whole lot of little things happening and building, and that's why people have always got to be comforted, inspired by the thought that theirs may only be a small and insignificant, or apparently insignificant contribution, but they all matter. And you never quite know which one is going to be the defining thing or the tipping point.
Arnold Stofile, the anti-apartheid activist who gave evidence at the hearing, believed that the case gave momentum to the struggle within South Africa.
We won the case, the rest is history, but in South Africa, that was a a momentous impact. And so many people knew about this campaign, and many people knew about the outcomes, and they were very, very excited. It's so excited that a lot of sports organizations mushroomed in a number of places to align themselves with our various regional councils of sport.
We should probably also note at this point that on his return to South Africa, Arnold Stofile was arrested on terrorism charges. Whether or not he had been involved in violence against the apartheid government, it is clear that his arrest at that particular time was linked to his involvement in the case. He would spend 3 years in prison. The Finnegan case also had another effect on New Zealand. It demonstrated that social movements could use the courts as a way of advancing their political causes through public interest litigation. Traditionally marginalized groups paid close attention to the case. As we have discussed in previous episodes, the court system had not traditionally been seen as a way of effecting social change. At the time of the Finnegan case, the legal profession was very much a white and male-dominated sphere, as you may have been able to tell from the interviews in this series. But times were changing. In particular, Māori groups and lawyers, many of whom had been involved in the anti-apartheid struggle, connected the Finnegan case to their own struggle for rights and recognition in New Zealand. Kevin Haig, one of the leaders of Heart, explained this to me.
The whole other dimension is really around the intersection of this, the kind of latter parts of the anti-apartheid movement and the movement around honouring the treaty in New Zealand. So there's a very considerable overlap during this period.
2 years after the Finnegan case, in one of the most important decisions in New Zealand legal history, Māori won significant recognition of their treaty rights in a decision now known as the Lands case. Sean Elias, one of the lawyers for Paddy Finnegan and Phil Recordin, and now New Zealand's Chief Justice, was also one of the lawyers in the Lands case, and Justice Cook delivered the decision in the Court of Appeal. In 2010, a survey of Court of Appeal judges suggested that the Finnegan case was one of the 3 most important in New Zealand history. Perhaps the lasting legacy of the decision was to show that in New Zealand, the law, through public interest litigation, can be used as a weapon of social change. Although these types of cases are rare, the actions of Paddy Finnegan and Phil Recordin demonstrate what can be achieved through determined and creative legal strategies. The decision in 1985 has given rise to inspiration and controversy, which remains to this day. This podcast was made with funding from the New Zealand Law Foundation and support from the University of Auckland Faculty of Law. Archival sound recordings are courtesy of Radio New Zealand and Taonga Sound and Vision. The audio from 1985 comes from the 16th of July edition of the Insight program. You can find a link to that full program on the podcast website.